Hello and welcome. My name is Matthew Newman. I'm Global Chief Correspondent at MLex, and I'm happy to host this podcast for the Privacy Rules conference that will be held on the 18th of November in Paris. With me today, we have a lawyer named Beatriz Rodriguez Gomez. She is an expert on privacy and cybersecurity and AI. She's been working for a law firm named RocaJunyent, and
Yes.
she's a partner there. She's a partner there. I'm going to briefly introduce the subject today, and then Beatrice will give an overview of some of the key points that will be discussed at the conference. So just to start out with, we're talking about the AI Act, and this is a piece of legislation that was debated for several years in Brussels, finally passed late December 2023, and it went into effect on the 1st of August 2024. And so far, we have a pretty tight deadline for when all the measures in the AI Act are going to take effect. So what we're working on right now is the AI office is up and running, and this is the EU's enforcement body that's going to be looking at whether or not companies are abiding by all the requirements in the AI Act, which is a risk-based piece of legislation for companies, and especially for what we call general purpose AI models. And that is important today because we're talking about the code of practice that will be drafted in the next couple of months. That will be in place, hopefully, by May. And then companies will have to abide by that. Companies that do abide by that code of practice, it will be assumed that they are following the AI Act. So that's why the code of practice is so essential. A lot of companies are involved in the drafting process, but not just companies, it's also NGOs and privacy advocates. And we have a whole list of stakeholders, literally hundreds of people are working on this. So, Beatrice, thank you very much for joining me today. Can you please just give us a little overview from your point of view of the importance of the code of practice and also what's going on with other aspects of the AI office, such as the template that the AI models need to follow to respect copyright rules. And this is a template for what kind of data that they are used to train their models. So that's quite important as well. If you could just go over those two topics for us, I'd really appreciate it. Thank you.
Thank you so much, Matthew. I'm very happy to be here. I think it's a very interesting topic, the one that we have today, and we are going to be discussing also in Paris. The truth is that the AI regulation has been a regulation that has been working for, or in which European Union has been working for some years, but it's been accelerated a lot since the last improvements on generative AI and new developments. And the truth is that the sector is still discussing how to figure out to comply with all these sort of obligations that are applying, how to identify it and be able to navigate through high-risk AI systems. And the idea is that this code of practice is going to be one sort of transparency and mechanism of self-regulation that is going to help organizations to navigate through this regulation. So it's intended to mitigate or to help companies mitigating risk assessment and the measures that are related to it. Also, copyright-related rules and transparency, which are like the main issues to be discussed at that moment. The truth is that the regulation intends to foresee what is going to be happening with AI, which is something very difficult by itself, and the code of practice intends to be a very useful tool for this sector for doing that. And the same happens with the standard rules and the regulation and copyright. This is one of the major risks that AI companies have and the AI system have, and that we are going to face. And it's very important that quality of the data and quality of the information that is nurturing that systems is appropriate. And the idea of all these initiatives is trying to be as useful and as helpful as possible in the shortest term possible, to be able to be or to have a market that it's working and it's operating and competitive with the rest of the initiatives in the world.
Excellent. So what do you think some of the main priorities will be for companies when they're looking at the drafting of this code of practice?
Well, it's going to depend on the sort of company, because you're not going to have the same perspective on depending on your position on the chain, for saying in a week. But I think that if the transparency and corporate obligations are clear, and the paths for risk identification and assessment measures are clear, that is going to be the more useful thing for the code to be operative. So I think that's where the focus is going to be set.
Do you think that there's a risk that the code will set unrealistic expectations that could lead to frustration and non-compliance by stakeholders?
Well, I think there's always this sort of risk. It happened before with some other codes. There's a risk that the code is not as determined as necessary to be able to be used as a guideline. And also it's a risk that the obligations that are set are not very real with the day-to-day of the companies, because normally what happens with these sort of regulations is that they foresee the most difficult scenario or the most high risk scenario, and they establish paths for that. But then you have a gray area in the middle where you're not in the most risky scenario, but you need to operate or to make something function. And that's when normally, for example, as lawyers are useful for, to be able to interpret a bit that and helping in determining where we are entering a high risk area or not. But yeah, I think there's of course a risk on that. We saw that also too for another initiatives in the EU, for example, with the European data sharing the space. And I think that here is going to be key the involvement of the companies and the knowledge share of all the stakeholders, to be able to make something very useful.
And for it to be really useful, I imagine that the code will lead to harmonized standards, and that will potentially lower companies' compliance costs. Do you think that's the ultimate goal of this exercise?
Well, of course, even the AI regulation sets a standard for the EU, or is supposed to set a standard, and that's the challenge always with the standards. The thing is that companies are in very different points at the moment. There are companies that are very, very technologically evolutioned, so that are more than prepared for making this sort of assessment and taking into consideration this criteria, and that have been working for years already in AI and in the principles that were going to lead the regulation. But there are a lot of companies that are much farther from this, and that they know they need the AI and they need the AI tools for being competitive, but they don't know how to face these challenges. And for me, that are the most vulnerable ones, also because they are the most common ones. I mean, for example, in Spain, the 99% of our companies are small companies, not that digitalized. So, it's difficult to make a standard that is good for all the sector. But I think we have to start at some point.
Well, Beatriz, that is all we have time for today. And I just want to encourage everyone who watches this to sign up for the conference on the 18th of November. It's Privacy Rules. It's going to be in Paris, and the details are available on the website of Privacy Rules. So thank you again, Beatriz. It's been a real pleasure talking to you, and I look forward to our session in just a couple weeks.
Thank you so much, Matthew. I've been looking forward to being in Paris with you all.